Awesome. All right, man. Hey, how you doing?
I'm doing well. Thanks for having me.
Yeah, of course. Thanks for making the suggestion. I don't think I've had a lawyer on the podcast yet, so surely this will be insightful for me and hopefully others as well. Maybe to begin, you can explain to people like who you are, what you do, and all that kind of stuff.
Sure. My name's Rob Freund. I'm an advertising and e-commerce lawyer. Also a big fan of Bill and amateur producer as of the last year or so. But what I do for work, I was a commercial litigator at a big law firm here in LA for close to 7 years. And a lot of what I was doing was defending big companies against consumer class action lawsuits. And a lot of those lawsuits in California especially involve false advertising. And the sorts of issues that come up in those cases are similar to the ones that regulators like the FTC enforce. When I decided that staying at a big law firm for my career is not what I wanted to do, I left in 2019 to start my own law firm, to have my own practice. And what I do now is I focus less on actually litigating those types of lawsuits and instead helping my clients avoid that kind of litigation in the first place by helping them ensure that their advertising and marketing practices are going to reduce the likelihood that they end up on the receiving end of a lawsuit or a investigation from the FTC or something like that. So the reason I reached out to you was there was an episode I was listening to that went pretty deep into FTC stuff and, what do we need to disclose and how does that work when you're doing some sort of sponsored content with a brand. And I thought, what are the odds this is right up my alley? And it seemed like you're interested enough to keep going into it a bit. And so, that's how this has happened.
Yeah, so the episode you were talking about was the one with Ben Jordan, and I believe, I think we were talking about some lawsuit that he was involved in, and I believe that you hit me up and you were like, actually, a part of what he said was incorrect, and this is like the literal thing that I do for a living, and that's why I know this. So yeah, I'm interested to dig into this for sure. So I guess a good place to start, like I basically know nothing about this stuff, so forgive me, my questions are like super basic, but I think also maybe other people will appreciate a really basic rundown on stuff first, just so we understand kind of where we are. So first of all, why is there laws why is there litigation around advertising?
Yeah, so generally, if we're going to keep the focus a bit on the government's perspective and why the FTC has the rules that they have and how they come up with these rules you're supposed to follow about sponsored content and stuff like that, the general policy idea is that people should know when they're being advertised to, and if they're going to make a purchasing decision and spend their hard-earned money, they might want to know that there's a relationship between whoever's making a recommendation or endorsement and the sponsor behind that recommendation. So if we're talking about those sorts of disclosure issues, like the FTC's broad stance is people should know what's an ad and what isn't, because otherwise they might not spend their money or might not spend as much of it had they known complete information. And like zooming out from that, like why we have false advertising laws generally, it's really the same flavor. It's like, if I'm going to make a decision to part with my money, I should have, nothing should be hidden from me. I shouldn't be lied to. We'll treat people as being reasonable consumers, but people should have as much information as a reasonable person would want if they're going to evaluate whether to buy something.
Yeah, that makes sense. So the law is there to basically protect people and to stop advertisers from running amok and just ridding everyone of their money for bullshit products and stuff like that.
Yeah, I mean that's like the pro-consumer version of it. I mean the flip side and part of the tension is it's not a perfect system. You can come up with and enact laws and rules that plaintiffs' lawyers will exploit and try to manufacture expensive lawsuits out of, when really it's like, what's the harm here? You can have a law that's like very, very technical and it can be exploited and turned into a class action. And the flip side of being pro-consumer is being anti-business. And so a lot of people, myself included from time to time, think the FTC is sort of too far on the anti-business, anti-entrepreneur side of that equation, and have sort of abandoned really concern for the consumer while encouraging fair competition. So there's that tension there between being anti-business and being pro-consumer.
Yeah, fair. So what is an example of, say, a case that you've taken on where somebody has done some sort of false evidence? And do you ever, which side are you usually on when you're taking a case? I guess, are you usually pro-consumer or anti-business? And what side do you find normally needs the lawyer?
Yeah, all the litigation that I've done, with maybe one or two exceptions, that has to do with false advertising, is I'm on the defense side for the business. So some consumer has found a lawyer, or often the other way around, which I could get into, and is trying to hold a business accountable or state some claim for false advertising. And my job was to resolve that to the client's satisfaction, whether that's, sometimes settling makes the most sense if they've got a good claim. Sometimes a client wants to fight it as aggressively as possible. But almost my entire career, almost all of it was on the side of the business.
And when you have a case brought to you, will you only accept the case if you're like, this is a reasonably defendable thing and I believe that the business was right? Or sometimes in music we'll take shitty bookings to get clout, for instance. We'll get a big booking at a huge venue or a huge festival, but they'll offer very, very low money because they know that you want to play that show basically because it's a good look.
Right.
And so sometimes we'll take on shows like that. A lot of my friends do this. I do this. Is there an equivalent of that in law where you'll get a case and you'll be like, okay, maybe it's not such a good case, but just working on it in general is good for your business? Or
on the defense side, there's less of a decision to make about whether it's a good or bad case to take on. In the way I operate now, now I'm in a position where I can make that call. When I was working at my previous firm as a senior associate, it's not up to me what cases the firm took. It's you're working this case now. But now if I'm deciding whether to work with a client, especially in the context of litigation, it's more about evaluating the client themselves. Is this a business that I think, it's a type of dispute that they're in, first of all, something I'm equipped to handle? And second of all, do I think that they strike me as just a scammer? Your radar to that sort of gets tuned over the years. If I think somebody is just out there scamming and is not really going to want to be a good client to work with, then I'll say no. But whether the business or the client has actually done what they've been accused of is a little bit less relevant. And really that just plays into the strategy of, okay, well, how are we going to deal with this situation? And there's also a lot of gray area. I mean, it's not always this client did absolutely everything they're being accused of. That's pretty rare. And it's also rare that there's something that's just no kernel of truth at all, and it's just nonsense. I mean, that does happen. But sometimes it's okay, well, let's get a full understanding of what actually happened and how that squares with what's being alleged and go from there. But if you got a situation where your client's, dead to rights, they did what they've been accused of doing, then the work is coming up with a strategy to how to get that resolved as quickly and as cheaply as possible.
Gotcha. So either way, it behooves you to work the case.
Yeah. On the other side of it, if you're representing a plaintiff, there's a lot more thought that needs to go into whether it's worth it to file a lawsuit in the first instance. What's our best day in court? What's the likelihood of collecting a judgment? What's it going to cost to get there? Does the claim even work? Which law applies in the first instance? There's a lot more of that consideration when you're thinking about whether to file a case in the first place versus okay, it's been filed, we have to respond. You can't just ignore it if you're on the defense side. So the work there is more about just figuring out what to do and not whether to do it in the first place.
I read on your website that you have a few things on your bio there that mention some cases that you've worked in, but they were just kind of like brief descriptions. Like the top one, for instance, said you defended a video game publisher against false endorsement and false advertising claims, including a dismissal with prejudice at the pleading stage. Can you talk any more about any of these cases, or is it kind of not a thing that you're allowed to talk about?
Yeah, I mean, without getting too far into the details, I'd be happy to explain what happened in that case. So this is a situation where...
Can you say who the video game company is as well?
I think I'm supposed to get their permission before I do that. I don't think it's necessarily even that relevant.
All right, yeah, fair enough.
But anyway, the client makes an action sports video game, and it's a game that's sort of like, you know how like in Tony Hawk you can choose from a cast of characters, like there's famous skaters and then you have the opportunity to make your own skater. In this game, like you could choose from a cast of like actual athletes, or you can create your own athlete that does this sport. And when they're making the game, it wasn't motion capture work, but it was something similar. And they needed somebody who knows how to do this sport to come in and like go through the motions so they can make the avatar character that you can customize. Like they need somebody to be the template. So they paid somebody to come in and do this. And then the game launched. It was pretty successful. It still has a pretty good following. And this person alleged that, well, I'm recognizable as the like default template character, and you didn't have permission to use my image and likeness in this game, in some of the trailers for the game, and some of the ads. Like this is clearly me, and the publisher didn't get a release from that person that said, you know, you can use my image in this game. And so the claims were for violating that person's publicity rights and for false advertising and false endorsement. Basically, the argument was, you know, you're associating my name. I am like a low-level pro athlete. I do get endorsement deals from time to time, and I get paid for those. And I would have asked for a lot more money if I knew you were going to do this. And so what you've done is unfair to me. And so at that point, like, the first point at which you can try to get a case resolved, if it's already been filed and you're in court, the first stage at which you can win in court, it's called the pleading stage. It's like the plaintiff has filed their complaint, and you have an opportunity at that point to ask the court to end the case before you get into like discovery and depositions and all of that. You can say, look, even if everything that they've alleged is true, those facts can't support the claim that they're stating or trying to state. So the job there was like, okay, even if everything this person is alleging is correct, those facts that he's alleged don't satisfy the elements of a claim for publicity rights violations or false endorsement. And so like the task is, okay, well, let's research other cases that have come out similarly, especially in the same court, and convince the judge that he should do or she should do what the other judges did in these sort of similar situations. And we were able to do that successfully, and the case was done. The client was very happy.
Interesting. So there's a few other ones here I'd also be interested to hear about. The next one says that you defended a pharmaceutical company against product liability claims, including affirmance of dismissal with prejudice on appeal before Ninth Circuit. I understand some of those words.
Yeah, that's going back a ways now. This was one of our clients at my previous firm. Was a big pharmaceutical company. And again, this is like, I'm in a situation where I don't get to pick who the clients are. Like
is that also part of the reason why you decided to kind of start your own firm and not work for those?
Yeah, absolutely. I mean, that's a big part of it. I really like that I get to, first of all, I get to know my clients now. I'm not just some like faceless associate that they see on a bill. And yeah, I get to be more selective, and I pick clients that are, or I get to accept clients that are doing work that I think is cool and not necessarily just pharmaceutical companies and stuff like that.
Right.
So this was a situation where it was like not like a headline big kind of case. It was basically the pharmaceutical company made like some kind of eye ointment, and this person claimed that they put this ointment in their eye and it screwed up their eyes somehow, and so they were trying to sue for like a product defect claim. It was complete nonsense. Like it was clear that this person had existing eye irritation. That's why they bought the ointment. It was a dumb case, but even dumb cases can incur a hell of a lot of work if you have to defend them. Like this went on for multiple years resolving this. So we established that in the federal court system, the first court you're going to is going to be called a district court. That's the trial court. That's where a case like this will start and end sometimes. We dismissed that case like at the same stage that I was talking about before. Even if everything you said was true, this is not a product defect case. You haven't said enough for that to be in play. Judge dismissed it. The plaintiff appealed it. So then you're in the Federal Court of Appeals, which in California is the Ninth Circuit Court of Appeals. The country's split up into these circuits, which are like groups of states. And you have one federal court of appeal that covers a number of states. So out here, it's the Ninth Circuit. And essentially what you're asking, what our job was at that stage was to convince 3 appellate judges, hey, the first court got it right. Every time something similar like this has come up on appeal, here's how you ruled before, and you should, like, here's why the court got it right in the first place. And we won that too. So yeah, that was not like the most interesting case in the world, except for dealing with some oddball personalities in the lawyer on the other side, but that's maybe a different story.
Right. What would you say is the most interesting case that you've taken on, the one that you enjoyed working on the most?
I really did enjoy that one with the video game publisher because that was, I think that was the first federal litigation I took on after I opened my own firm. So it was cool that a client who made a game I had heard of and played before, first of all, like was able to get in touch with me and then trusted me to handle this matter for them, and that we were successful in it. So it's like combination of cool client, cool subject matter, and a win was like probably the most satisfying case I worked on. Other interesting ones. There was a case I worked on at the previous firm involving a reality show. Basically, a couple cast members on Dance Moms were suing each other for a number of things, one of which was for allegedly assaulting one of the moms. The reason this case was interesting to me was because all of the allegations that were in play here were filmed, like they were all in the episode. So part of my job as an associate was like very, very closely watching episodes of Dance Moms and like trying to analyze what was going on there. So that was kind of a nice change of pace from a lot of what the other work entailed.
Yeah, interesting. And have you worked on any music cases, or like where is the crossover, I guess, between sort of what you do with advertising law and music?
Yeah, so what comes up a lot lately is brands that want to use music in advertising and how that works with things like TikTok's music library versus like their public library versus their commercial library, and how does that work, and why did Bang Energy get sued for so many millions of dollars for what their influencers were doing with music and their posts. So there's a lot of confusion still about what's okay to use in social media content when it comes to music. Music also crosses over in my practice sometimes with, there was a client I had that has educational products about like how to mix properly. And like any business that relies a lot on online advertising, they want to run promotions from time to time. And that's the sort of stuff that I advise on pretty regularly. Like, hey, we want to do a giveaway or we want to hold a contest. What do we need to have put in place to make sure we don't end up in trouble running a promotion like that? Or we want to run a sale for X amount of time or for this segment of the audience and things like that. And that's what I do mostly now, as opposed to being in court, is I'll help my clients set up their advertising campaigns in a way that reduces the likelihood that they would need to hire me to help them get out of a lawsuit.
Yeah, that's wild. This is something I've never even thought about when like running an ad on Facebook or something like that. I never have even thought like this could create a problem and I could get sued from the way that I'm telling people to buy my thing. So what is like some good advice for people who are running ads for, say, I don't know, their shows or their new educational course or whatever? Like what's just like a pretty good standard practice to keep you out of trouble?
Yeah. So for courses in particular, some of the things that come up a lot are if you're guaranteeing any kind of results, you need to be really careful with that. This applies more to people who are doing like work from home courses or, business coaching and stuff like that. But it could apply to something like people who teach marketing courses or even fitness courses or whatever. If you're going to showcase like student results and testimonials, you want to be mindful of whether those are exceptional results that you're showing people through testimonials, or whether that does reflect what the typical person can expect to achieve. So if I'm selling a course about, like, a common one I see is like Amazon automation. There are these courses that purport to teach you how to get rich quick from home, and they'll show client testimonials like Mark made $100,000 in a month. The FTC would tell you if the typical student cannot expect to make $100,000 in a month, then you need to clearly and conspicuously disclose what the typical expected result is. It's not enough to just say results not typical. If you're going to showcase one result, the law will assume that that's the average result, and if it's not, you need to tell people what the typical result is. So that's one that comes up a lot when people are selling educational materials. Another one is, and this applies to like direct to consumer brands and retail scenarios and not just courses, but I see it with courses a lot too. And Udemy got sued for this, and I think they paid $4 million to settle this case. The issue was using like strike-through pricing, like was $100 now $10. There's a federal law about it, and there's very specific state laws that define the boundaries of what you can do when you're marking something down from a former reference price. Like you can't run a sale forever. There's time limits on it. You can't like mark up an item just for the purpose of marking it down to make it look like somebody's getting a deal. So those two things come up a lot with courses. And then the third sort of broad one that I would say is good to keep in mind is like using other people's content in your content. So if you find a video on Instagram or something of a student who's raving about you, and you think like, oh, that's a great video, I'm going to use that in my ad, you need to clear the rights to use that person's content. There's a misconception that if some user out there like tags my brand in their content, that means that I can use it because they're tagging me. And so it's like understood that I get to use that content, but that's not the case. You can run into copyright issues. You can run into publicity rights issues. So any content that's in your advertising that you did not create, it's good practice to make sure you clear the rights to all of that.
How does state and federal law even come into play with online advertising? Because, for instance, like I'm based in Georgia, right? But I might run an ad for my educational course to people all over the world. What law am I subject to at that point? I can't speak to how many other countries do it. But basically, if you're running a nationwide ad campaign, the federal law is going to apply to you. So the FTC's rules about advertising will apply if you're running an ad in the United States. If you have customers in California, like let's say you're running an ad and somebody in California can buy a product and have it shipped here, then California law can apply too. So it's conceivable that every state's law and federal law could apply to whatever your advertising is if you're running a nationwide ad campaign. Yeah, gotcha. So sometimes I see advertising where it'll be like for instance, a testimonial, right? But then that testimonial, which is obviously like best case scenario, has a little asterisk on it. And then if you like read the fine print where the asterisk is, it says like this testimonial is not normal and this is like a really insanely good case and results may differ or whatever. Does that make that case then legal, or is that still also a thing that could be fought in court?
That is something that the FTC has paid more attention to, in particular, in the last couple of years, and they've re-emphasized that sort of fine print disclosures don't cut it. For a disclosure to be effective legally, it has to be presented clearly and conspicuously, is the term that the FTC uses, and that basically means unavoidable. So if it's possible that a reasonable person could miss it during their process of viewing the ads and through their purchasing journey, then that's not an effective disclosure. And then in the specific case of, results may vary or results not typical, it's not enough to just say that or to say that this is an exceptional result. You have to go the extra step to say the typical result is X.
Yeah, that makes a lot of sense. Yeah, I've never even thought about this stuff. It's kind of crazy. And I guess that given that I've run a fair few ads and never run into it, either means that I haven't done anything wrong or that someone just hasn't decided to sue me about it. But like, so for basically all of these cases, it's going to take somebody receiving an ad, getting tricked or whatever, or buying the product and then being like, that was bullshit, and then deciding to sue the person and take them to court, right?
So sometimes it's lawyers whose business it is to bring these lawsuits will come up with the theory and identify the targets they want to sue, and then find a plaintiff, like a consumer, to match their theory. And that's just the reality of it. So like, let's say if I'm on that side of the fence and I'm like, okay, I'm noticing that a lot of online brands are marking down prices that I can determine are fake. Like, you never actually sold that for $100. And it's not complicated to figure that out, which is why I'm using this example. If I'm on that side of the fence as a lawyer, I might say, okay, let me go through all these websites, find examples of this, try to figure out how much money these businesses have to see if it's worthwhile for me to sue them as the lawyer. And then maybe I'll run an ad campaign like, hey, have you bought such and such product from this company in the last 3 years? Like, fill out this form because you might be entitled to, or there might be some recovery for you. And then you go through and see all the responses and say, all right, this is a California person. They bought it within the right amount of time. They're interested in participating in this. And then that's how some of those, or many of those, cases get started. So it's not always somebody, because it's easy to think like, well, who's going to get pissed off enough over like a $3 bag of chips to bring a federal lawsuit about it? Well, maybe no one, but the lawyer who's incentivized to bring it really wants to find somebody who's interested in going along with it. And so that's a lot of how these things get generated.
Yeah, that's wild. What a fucking sad existence. Just sitting around being like, I'm going to find a problem. I'm going to find that doesn't affect me, but then I'm going to find the person who it did affect just so I can sue this company and try and get money.
Yeah, and it's pretty dark looking at it that way. They would try to tell you, well, if nobody else polices the market, then you can't keep fooling people for a little bit of money on a big scale like Superman 3 or something and take like a few pennies out of a million people. And if I'm not doing it, then these businesses will just get away with it. And it's not fair to competitors who aren't doing that. And so I'm cleaning up the marketplace. That's what they would probably tell you. But,
it's a reasonable point, I guess.
You sort of like back into your moral choices based on what line of work you're in, I guess.
Yeah, to me, I personally could not think of a more possible boring thing to do with my time. It's just sit there online trying to find people like just coming up with cases like this. I mean, everyone's brain works differently though. Like, I've met a lot of people who like advertising for them is just the sickest shit ever. They love it. They will come up with like a bunch of campaigns. They'll run a bunch at the same time simultaneously. They'll figure out which one's doing well, then stop all the others and dig further into that one. And like, they're all interested in people's psychology and all sorts of shit. And to me, it's like, I start looking at like the Facebook ad page and shit, and my eyes glaze over and I just get so bored so quick.
Yeah. I'm glad those people exist, though, and I'm glad that they're out there. I'm glad that people care enough about advertising that they want to do it, because it's not something that I certainly want to do.
Yeah, speaking of being proactive, I guess, how do you, like, I imagine the laws change constantly. So how do you stay up to date with that? Are you basically just having to sort of reread the law like every other month to try and make sure that everything in your, like the information in your mind is updated constantly with those new laws, or?
So there's a couple of things I do to stay on top of everything. One of them is just I have alerts set up for cases that are filed or orders issued from courts that relate to the sorts of issues that I pay attention to for my clients. So like anytime a lawsuit is filed that includes the word influencer or former price or automatic renewal or something like that, I get a little alert through my research platform, and I also have a Google alert set up for those things. And I scan those every single day just to make sure that I have an idea of what's going on. It also is how I create content for my Twitter, which is how I do my marketing. So it's like kind of getting two things done at once. And then there's a number of legal blogs that are dedicated to the areas that I practice in too. Like there are legal advertising blogs from big firms that publish stuff. So I'll check those every day and make sure that I'm not missing something, or that their assessment of some situation jives with mine. And that's basically it. It's like monitoring activity every day and making sure that the other people paying attention to this and I are in agreement, so that when some new issue comes up for a client, I can give them the most current advice.
That sounds like a lot of work.
Yeah.
I don't think there's anything other than writing music or something that I do every single day without fail. That would be like the equivalent of me setting up like Google alerts and notifications for every time a new piece of music technology comes out or something. And I should probably do that now that I think about it, but I don't. I just like wait until somebody tells me about a new plugin before I find out about it, really.
Yeah. Well, then there's probably people like me who hear about new stuff from you. So like
I feel like that's generally how a lot of the music industry works, is word of mouth a lot of the time.
Yeah.
So how did you get into specializing in this kind of law, and did you kind of know from a young age that you wanted to be a lawyer? Like what was the path that led you to get into that stuff?
Yeah, I don't have a story about always wanting to be a lawyer when I was a kid or something like that. The honest truth of it was like I didn't really love any subject in school growing up. Like I was not a good student pretty much until law school. I was pretty good at taking standardized tests, which basically carried me through up until that point. But people had asked me, my parents included, like, well, what are you passionate about? Like, don't you like science or something like that? And I was like, I do not have a good answer for that. Nothing is really getting the juices going. And so I was like halfway through college, I'd majored in economics. I knew I didn't want to go into finance, which is what a lot of people did from that program. I was like, okay, well, I do want to make enough money to live comfortably. What are the options for like what seem like stable careers where you don't need specialized, like you don't appear to need to be passionate about anything in particular? I was like, well, law school seems like an option. At the time, I thought to myself, I don't know any lawyers who are, struggling to make ends meet, which is totally untrue. It was just a misconception I had. I thought, okay, like you go to grad school and then you get your degree and then like you have a comfortable life. And I could see wanting to argue with people and, come up with arguments and be in court. That seems like it could be fun. So we'll just sort of do that. And I spent a summer interning with a lawyer in Virginia Beach where I grew up. And that sort of pushed me over the edge of wanting to do it because he lived a life that looked like one that I would want to live. Like he had enough time to spend with his kids and his wife, and he still made time for surfing on the weekends, and it was really cool to me. And like, just it seemed like, yeah, that's something I would want to aim at. So I'll just do that. And the reality of becoming a lawyer is a lot different from what I thought when I was a kid, and I think what many people think. Like, it's definitely not a guaranteed stable career. There's a wide disparity in terms of how it can play out for you. How I got into doing what I'm doing today was, of all the areas of the law I was exposed to, the most interesting to me was the stuff that involved advertising, because of that psychological element and the dynamic between what marketers want to try to do because they know what works from a psychological perspective, and then how the government tries to respond to that by making laws that constrain it, and then the courts, like in the middle of it, trying to interpret that law and apply it to new situations where marketers are getting creative. That kind of stuff was way more interesting to me, because like, you have to spend a lot of time reading about whatever the subject matter is. I really did not like reading about like mortgage foreclosure cases, which is something I worked on for a couple of years, or like real estate cases. Very hard for me to want to get fired up at all to read about that stuff. But the false advertising issues were just more digestible and more inherently interesting. So I was like, okay, please give me more of those cases. And then towards the last couple of years I was at that firm, we would have more clients come to us, who haven't been sued yet, but they would say, like, look, for example, Activision was a client of that firm. And they would say, we got this big game coming out. We're going to run these ads for Destiny 2. Can you take a look at them and tell us, like, is there risk here? Is there anything we should be doing differently? Have our competitors gotten in trouble for something like this? And I realized I enjoyed that kind of advice and counseling work a lot more than the actual litigating. So I thought, okay, it's time to go start my own firm. If I could just do that kind of work 100% of the time, that's what I want this job to look like for me. And I've been fortunate that I've been able to do that, and that's pretty much all that I do now.
Yeah, that's awesome. Yeah, I feel like a lot of people's lives are like that. Like, you start doing a thing, you realize that there's all these other jobs that come within that job, and then you find the one aspect of it that you like really want to specialize in, and then try to like just dig down into that a little more. And I feel like I've kind of had the same thing. Like, I got into music, and then I started doing like all sorts of shit within music, like shows and podcasting and like all this stuff. And slowly over time, I'm like whittling down the type of work that I want to do within this industry. One thing that I'm really... Sorry, go on.
I was going to say, it's interesting how that works out. Like, you hear that a lot with lawyers and just people in general. Like, oh, how'd you get into this really specialized thing? And they'll tell you it's kind of by accident, or I didn't mean to. And then it ends up just being what they do. So
yeah, you just find a thing, and one day you're like, oh wow, this thing is like super fun, and I just would like, if I could just do this, that'd be sick.
Yeah.
I got a question about like AI stuff, and not really a question, just kind of like your thoughts, I guess. Mm-hmm. Like, where do you see? I know that like copyright law is not necessarily a thing, but or maybe it is an aspect of what you do, but like, where do you see all of that stuff going? Like, if somebody say trains a model on, I don't know, just some giant public library of pop music, and then they start like generating tracks from that, and maybe not necessarily releasing them, but using them maybe as background music for their YouTube videos, or maybe using them in their ads or something like that. As far as I know, which I might be wrong because I don't have Google Alerts set up, there might already be laws surrounding this kind of stuff, but as far as I know, it's like pretty gray area still. So maybe you could like tell us, if there is laws that you know about surrounding this stuff yet, and if not, where do you see it going based on where you've seen laws go in the past?
Yeah, they're really big questions, and they're questions that are being worked out in the courts as we speak. So the law that we're dealing with is the Copyright Act, which is really old. And one of the broader discussions within intellectual property law for a long time has been, do we need to update the Copyright Act? Should it be reformed in some way? We're still applying this effectively ancient law to situations that could not have been imagined when it was written. And so with AI, to sort of summarize how that's playing out right now is two of the big questions are, when you train a model, does the act of training constitute copyright infringement? Like if I take your discography and feed that into some model, by effectively copying your music and inputting it, at that stage, am I committing copyright infringement by doing that? And then the other question is, when the model generates some output, who owns the rights to that, if anybody? What a couple courts have said so far, and this is not something that I check in on every day, but my understanding is that this is still current, is like a couple courts have come out and said, whatever an AI model outputs, if some content is created entirely by a piece of AI, then it's not copyrightable and nobody owns the exclusive rights to it. The question that's sort of pending is that first question. Like if I take work that is protected by copyright and train an AI model with it, is the act of training an infringement of copyright? And we don't know what the answer to that is right now. And I'm not sure that I can predict how the majority of the courts will come down on that decision. I think ultimately what's going to happen is you're going to get different results in different parts of the country, like you do with a lot of different copyright issues. And then probably at some point, the Supreme Court's going to have to weigh in and tell us what the deal is with AI as it relates to copyright.
So it was my understanding that copyright infringement happened at the point of like release or sale, right? Like if I, in my studio here on a computer not connected to the internet or anything like that, if I, take a Beyonce a cappella and throw it into Ableton and make a remix or something, that's not the copyright infringement. The copyright infringement, this is my understanding of it, I might be wrong, is when I render that and then put it on the internet for people to say buy on Bandcamp or something. Is the point of copyright infringement then when I put the Beyonce a cappella into Ableton, or is it when I upload it to Bandcamp?
So technically, one of the exclusive rights that a copyright gives the owner is the exclusive right to make copies of it. It's also the exclusive right to distribute it or perform it or sell it and things like that. But one of those rights is copying. So if I took one of your songs and ripped it from YouTube, at the point I've made that copy, I have infringed on your copyright. The point that it matters for practical purposes is when I go to try to sell it, because that's when you're going to care, if you care. You probably do. But what are you going to do? Take me to federal court because I made a copy on my computer? Maybe. But technically or legally at that point, I have infringed on your copyright because I have made an unauthorized copy of a work that is protected by copyright.
Fair. And I imagine it's just going to get like exponentially and insanely complicated if you then train an AI model on, say, the top 500 pop artists in the last 50 years or something like that. Because then it's like, how do we divide this up? Like, how many songs were there from the Beatles? How many songs were there from the, Elvis? How many songs were there from Kanye or whatever? And then you have to figure out like the length of those songs, how many writers are attributed to all of those songs. I was actually thinking about this the other day, and I'm not a fan of like NFTs or really crypto or anything.
Me neither.
But I mean, this kind of like smart contract technology that they all, talk about and say is like the revolutionary tech behind the whole thing, sounds like if it works the way that they, claim that it works, which it probably doesn't. But if it does, I mean, that seems like it could be a solution, right? Like having these really elaborate smart contracts that can just sort of run down the chain and distribute micro amounts of funds to however many people.
Yeah, if you set up the actual agreements that relate to those so-called smart contracts correctly, you could conceive of a way where that could be achievable and could work. The thing about like smart contracts is they're not smart and they're not contracts. It's just like a line of code that executes something. You need to have an agreement between the parties, like this is what we've agreed this code is going to do. And, if this situation happens, then this action will be taken. And here's the parameters of what we want that to look like. Like just having a piece of code that will automatically execute some function if a certain condition is met, like that's not what a contract is. So you can, I'm also very cynical about blockchain technology in general, and I'm pretty anti-NFT. So, could you develop a system that fairly and efficiently handles much more complicated like royalty and licensing issues that AI presents? Yeah, it wouldn't be simple to do, but it could be done. But the amount of work that would go into making that run smoothly, it's unfair to just sort of like hand wave and say smart contracts will solve this. And that's like what the NFT community loves to do for like every big problem, is say, oh, a smart contract will take care of it. And then people are just like, oh, right, okay, cool.
Yeah, I feel like all crypto people kind of live in this like utopian world in their head where they're like, where I understand what they're saying. Like, yes, if this technology was adapted by everybody and everybody used it exactly how they were supposed to, and nobody was like being greedy and trying to fuck with it or anything like that,
right?
Then yes, it's great technology. But the fact, especially with coins like Bitcoin and Ethereum and stuff, is that the whole point of it is to try and decentralize everything, and take away power from the banks and whatnot. But all that's happened is a couple of big players, or whales, I guess you call them, have bought up the majority of the coins and are holding on to the majority of the coins, and therefore the power is still centralized. It's just centralized to those people with the biggest holdings, because now that they can control the entire market by selling off massive amounts or trading massive amounts or anything else like that. And the other thing I fucking hate about crypto is they're like, yeah, Bitcoin, 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 but they constantly are measuring it in how much US dollars it's worth.
Right.
And it's like, why? Like you're literally telling me that this has the value of this many US dollars, but you care about Bitcoin. It's like, no, you clearly are still caring about US dollars.
Yeah. And then they'll say like, oh man, I should have sold when. It's like, why are you talking about that? I thought this was the money. Like, what do you mean you should have sold the money? And then the other thing, like while we're at it, is I'm not so sure the idea of decentralization in itself is like an inherently good thing that you should want. Like part of the reason I like banking is because if my money gets stolen, it's insured like up to $250,000. And crypto is used all the time to steal money from people. And then people will complain like, oh, I have no recourse. It's just gone. It's like, yeah, that's because it's decentralized. Like that's the biggest benefit, or one of the biggest benefits of having central banks, is that your money is protected. So it kind of, I don't know, it frustrates me when just the goal of decentralization for its own right is held up as this thing that we all should just agree is what we should be working towards. I don't know. I think like not one bank should have all the power, but centralization can be okay.
Yeah, I also agree that fractional reserve banking has a lot of problems, but yeah, I also think that there should be some sort of like moderation and some sort of like, you know, like council or something that like makes some decisions for everybody, and they are controlled by like another council or another entity or something. I think it's working. It's doing a decent job. Speaking of which, there was a case also on your bio that said that you defended an international bank against fraud claims, including affirmance and dismissal, with a bunch of shit about the Ninth Circuit again, which I still don't fully understand. But so I'd be interested to hear about that case. And also, have you had to deal with any cases in crypto yet?
Yeah, so that case, let me try to remember the details of that one. I think this is like 2015, maybe. It was a situation where somebody who owned a restaurant around here had someone working for them, and that person stole like a significant amount of money out of the business and embezzled it. And the main lawsuit was between that business owner and this former employee, but they also sued this bank that was involved, or the bank where the money was held, because the claim was that like some bank teller was in on the embezzlement and authorized checks without going through the proper procedures. And so they aided and abetted the fraud and should be held like jointly liable for the loss of the money. That was a claim that was not that difficult to deal with. Like you can't, even if it were true that some bank teller somewhere was persuaded to get involved in some kind of conspiracy, you can't always attribute the act of an employee and hold the company responsible for that act if it's like way outside of what this person's supposed to do as part of their job. And for a number of other reasons, we were able to convince the court, like, look, first of all, what they're alleging is like very obviously not true. There's some situations where if you're going to debate, like the default is if you're going to try to win the case based on determining what's true and what isn't, you don't really get to do that at that first stage of the pleading stage. You have to get into discovery, and then it's like either at trial or there's a stage before that where you can say, okay, now we have all the evidence and what you said happened didn't happen. But in some situations at the very beginning, if the plaintiff alleges something that is on its face not true based on like an official government record or something like that, the court doesn't have to accept what they're claiming to be true. And this was one of those situations where we're like, look, they said that this money went missing, or they discovered that it was missing in 2017, but here's like an email they included in their thing that said they knew about it 2 years before that. So like they're out of luck. Long story short, we won that. They appealed to the Federal Court of Appeal again, or not again, but similar to that other case. And then we took on that extra piece of work of convincing the Court of Appeal, like, this is how, like, the trial court got it right, the district court got it right. This is how courts in California address these sorts of conspiracy claims. And we were able to get the win at the appellate level too. So it was one of the cases I was more significantly involved in than other cases I had previously been at that time when I was like 4 or 5 years into my career. So a satisfying win for us at the time.
How I've heard stories before, and they might be myths, that often lawyers are friends with the judges, and that's often a way that they kind of, get better results than maybe other lawyers or something. Is that a thing that you've seen much in your career, or is that kind of just bullshit?
I think that if, to the extent it happens, and I'm sure it does, I think that happens more in like smaller cities and smaller areas where there's not that many judges and maybe not that many lawyers. And, you run into the same judge at the same lawyers and judges like events and stuff like that. In Los Angeles, like, we have so many judges and there's just so many attorneys that I never directly saw any situation where I even suspected like, oh, this judge and the lawyer are buddies, or like they used to work together a couple of years ago. I'm sure that thing does happen, and like, people are human. There might be some friendship that weighs in some capacity on a judge, but they're supposed to set that aside. And if they feel that they can't, they're supposed to recuse themselves from the case and let a different judge have it. So it hasn't really come up in my career, but I'm sure that it does happen in a way it's not supposed to from time to time, and probably in more rural areas.
Right. And how often have you come up against the same judge in your career, ever, or is it always a different judge, basically?
A few times I've had repeats, but the judges, especially here in California, have so many cases on their desk at one time. I mean, it's in the hundreds of cases at the same time. So they may not remember me like a year later when I'm in front of them again. Or if they do, it's like they have no idea what I was doing there the last time they saw them. And oftentimes, like, they're so busy, like, and lawyers will forget this too. Like, nobody cares about your case as much as you do. Certainly the judge isn't like, oh yeah, I remember 6 months ago when you were in here, we were arguing about this thing. Like, they just don't have the bandwidth to pay to super close attention to everything that's going on every single day, because they have like 400 cases they have to tend to at once. So, I've been in front of the same judge multiple times, but I don't know that it mattered to them.
Right. Is it pretty common, like, to become a judge, do you have to basically be a lawyer first for a good period of time and then that's how you become one, or like, how does that even work?
Yeah, you have to be a lawyer for, I don't know if there's an amount of time. I've never looked into it because it wasn't something that interested me in terms of like how you go about doing it. But I do know, like, you do have to be a licensed attorney. I'd be surprised if anybody became a judge within the first 5 years of practice. I don't know that that would make very much sense. And then at the state court level, it's an elected position. So in local elections, people will literally vote for judges to sit on the bench. At the federal level, they're appointed by the president. And the judges come from a variety of backgrounds. Federal judges maybe were state court judges before, or maybe they were federal prosecutors or federal public defenders, and sometimes they've been in private practice, or in some cases they were academics for a while, or they worked for a government agency or something like that. So it's kind of a diverse pool of attorneys that do end up becoming judges. But yeah, you have to be a lawyer first and do it for a bit of time before you can be seriously considered for it.
And generally with cases, are judges picked sort of at random, or are they generally picking judges that are specifically good with this like type of law to go for that type of case, or is it just any judge, any case, just out of a hat basically?
It depends a bit on the court system. So some court systems are broken up in terms of like broad category. Like there's family court, and any kind of family law dispute, you're going to get a family law judge, at least here in LA. And there's like probate court for contested wills and stuff like that. Within those divisions, the judges are chosen at random. And then for pretty much all sorts of business disputes in LA County, at least, any of the judges there's like a larger number of judges that could be chosen at random. In federal court, there's overlap between civil and criminal cases. So a judge can have criminal cases on their calendar in addition to civil matters. And again, it's just the federal judge you are assigned is determined at random. You have the ability to ask for a different judge one time per side. So at least in state court, you can say like, okay, this judge, like there were a couple of judges that at the previous firm, if they were drawn, we would just use that re-roll because for whatever reason, we didn't like that judge. Either we felt like they just didn't read the papers, or they were super anti-business, or whatever the case may be. It's like, okay, this judge, we're going to use our peremptory challenge and like re-roll the dice again. And we don't really care who we get next. It's got to be better than this judge. So that's pretty much how it works. It's random, and then there's an opportunity to re-roll, basically.
Yeah, interesting. Well, cool, man. I appreciate you chatting with me. This has been really interesting. And yeah, I apologize if it hasn't been interesting for you. I feel like
no, I mean, it is. Not at all. I like talking about it. I hope the audience, wherever I'm talking, is into it a bit too. I just wanted to say, while I have you, like, thank you for putting together Art of Bill. It's so incredibly helpful for especially people like me who are pretty new to the journey, to watch you work through all of it. Incredibly helpful. Thank you for doing that.
Yeah, of course. Yeah, I'm glad that you found it useful. Yeah, to anyone listening, if you haven't checked out The Art of Mr. Bill, check it out if you want to learn how to make music, and hopefully me saying that is not illegal.
It's your stuff. You're welcome to do that.
Nice. All right, man. Well, yeah, thanks a bunch. I appreciate you chatting.
Yeah, this is cool. Thank you.